We're back at ABI's Views from the Bench at Georgetown University Law Center, now talking with Cecily Dumas of the San Francisco office of Pillsbury, Winthrop, Shaw, Pittman. Cecily just did an awesome panel on claims trading in Chapter 11,
Thank you,
so we wanted to talk about some of those cases. Let's start with the Supreme Court case, the Village of Lakeridge. Where the Supreme Court often does, there's a narrow holding,
Yes.
And avoiding sort of the big issue. So what is the big issue in that case that the court left unanswered? And,
Yes.
and what do you think hints did they leave that suggest what the answer might be?
So what the court did is the Supreme Court limited its review of the case to whether the Ninth Circuit applied the right standard of review of the bankruptcy court's decision. And that was a more deferential standard of review, clear error, as opposed to what we call de novo review, or looking at everything fresh from the start. And I think the temptation that the court resisted to adopt a higher standard arose out of the facts of that case. A non-statutory insider is someone, the decision arose out of the transfer by an insider of the debtor to a gentleman friend, I'll call him, who didn't seem to be interested in much other than doing a favor for his friend. Although they were not family members, they were not cohabitating, as the bankruptcy judge put it. He didn't give her expensive gifts, and she didn't give him expensive gifts. But nonetheless, this looked an awful lot like engineering, getting the plan confirmed through a friend. And I think every appellate judge who looked at this particular case thought, I don't know that I would have agreed with the bankruptcy judge's assessment that this was an arm's length transaction, that this person was not a non-statutory insider. So good for the court for resisting the temptation to really take over
Right.
what the bankruptcy court should be deciding in the context of maybe thinking a different result should have happened at the bankruptcy court level.
So the high court stayed in their lane, so to speak.
The high court stayed in its lane, and it did, the concurring opinion suggested that maybe the test that's employed by the Ninth Circuit for what is a non-statutory insider may be subject to review at some point, but pulled back from actually changing that test. And as the court often does, it'll wait until there's, a fulsome difference of opinion at the circuit levels before it takes a substantive issue like that. Very fun case to talk about. Thank you.
Well, let's turn to another Ninth Circuit case, and this is on the propriety of buying claims for the purposes of blocking, and whether or not that is good faith, bad faith, and what are the factors that courts consider when making that judgment. Another Ninth Circuit case.
Yes, in this case, there was one secured creditor who was owed about $10 million, and then a group of unsecured trade creditors who were owed much less. And the bank's counsel, as is not unusual, was given permission by the bank to go try to buy some of those claims for the purpose of blocking the unsecured creditor class from approving a plan over the bank's objection. That is a cram-down plan. And what the bank succeeded in doing was buying more than 50% of the claims in number for the princely sum of $13,000. And it was very interesting in the panel because, in particular, and the Ninth Circuit said, no, the bank was trying to protect its self-interest. That is, it was not in its interest to get crammed down and have its payment stretched out. So that was a valid good faith exercise of self-interest. And what Judge Drain said, which I found particularly compelling, is, yes, but where is the line? Because unsecured creditors were hurt. The plan that was voted down due to the bank's having obtained a blocking position would have given unsecured creditors 60 cents on the dollar. Instead, they got nothing. And how do you measure one party's robust pursuit of its self-interest versus the harm and damage that can be done to other parties, maybe with less ability to affect the outcome of a case? So that was a very good discussion, and we didn't really reach a conclusion on that. stay tuned.
It'll get litigated again for sure.
I'm sure it will.
Well, thanks for a great panel,
Well,
Cecily.
thank you very much for
Action,
inviting me.
action packed.
I love this program, and I appreciate being a part of it.
We'll be back with more after this.